Trillium Motor World, and General Motors. Over 100 law firms third-party in a class proceeding arising from the bailout of General Motors is the factual backdrop for our first case. The class members are terminated GM dealers who sued GM, alleging that they had been forced to sign wind-down agreements. They also sued Castles, Brock, and Blackwell, alleging that they had received negligent advice in relation to the execution of those agreements and with respect to certain protections available under franchise law. Castles Brock defended the case, arguing that it had never provided legal advice to the individual dealers. It third-partied the law firms whom it said it had provided that advice, seeking contribution and indemnity. This appeal arose following a failed jurisdictional motion brought by 32 of the Quebec law firms. They had argued that none of the presumptive factors from the Breda decision were engaged in this case, such that the Ontario Superior Court did not have jurisdiction. The Court of Appeal, however, agreed with the motions judge, finding that the wind-down agreements were a contract executed in Ontario that was sufficiently connected to the dispute in this case. They rejected the contention, both at the motions level and in the Court of Appeal, that the only relevant contracts for the purpose of the third-party claim were the individual retainer agreements between the law firm and the individual clients. Left to another day was the issue of whether the fact that the defendant law firms were national law firms with offices in Ontario were sufficient to meet the second branch of the Van Breda test, or the second factor in the Van Breda test, namely that the defendants carried on business in Ontario. That issue, and whether or not it could be rebutted by the fact that in fact all of the transactional work was done in another province, will have to be determined on different facts in a different case. Harris and Leikin Group. This is another case arising from a rift in a family business, here a shopping center controlled by 11 grandchildren of Harry Leikin. 8 of the shareholders sold their interest to the 3 remaining shareholders based on a value of $60 million. A week later, however, the 3 shareholders sold 50% of the interest to First Capital Realty based on a value of $78.8 million. The 8 shareholders then sued their cousins, First Capital Realty, and a number of lawyers and accountants for a share of the enhanced profit. The claim against First Capital Realty was dismissed on motion for summary judgment, and the motion judge ordered a hybrid trial. At that hybrid trial, the claims by the 8 shareholders were dismissed. They appealed, alleging procedural and substantive errors, and in particular said that the use of the hybrid trial had robbed them of their ability to control the trial narrative. The Court of Appeal disagreed, however, stating that if they had concerns about the hybrid trial, the time for appealing that decision was at the time for the motion for summary judgment, not after they had participated in the trial process. Importantly, the use of the hybrid trial was an appropriate use of the resources arising from the motion for summary judgment, and the Court of Appeal noted that the trial judge had given the parties considerable latitude in the presentation of the evidence. Accordingly, this was an appropriate use of a hybrid trial, and the claim and the appeal was dismissed. Baywood Homes Partnership and Haditaghi. The Supreme Court of Canada's decision in Herniac was considered yet again in our next case. Here, the motions judge was faced with 2 competing motions for summary judgment, one on a main claim that was based on fraud and allegations of breach of contract, and on a second claim or counterclaim based on a failure to pay on a promissory note. Interestingly, the motions judge summarily dismissed the main action, finding that it was precluded by a release which the motions judge found was authentic and valid. However, even following a mini-trial, the motions judge felt that the promissory note claim needed to go on to a full proceeding. The Court of Appeal, however, disagreed with this procedure. It found that the release and the promissory notes were part of a series of transactions, and that the motion judge erred in principle by not considering the advisability of hearing the motions for summary judgment and addressing them in the way that he did, given the context of the overall litigation. In addition, the Court of Appeal again put forward a warning about determining issues of credibility based on affidavit evidence, here based on cross-examination evidence revealed in a transcript. The Court of Appeal again noted that credibility issues often need to be determined with the benefit of hearing the affiant's, quote, authentic voice. Simpson Wigle Law and Law Pro. In this case, the Court of Appeal had to consider whether or not claims in a statement of claim were sufficiently different so as to give rise to two claims for the purpose of an insurance policy, thereby increasing the aggregate limit available to the insured. The application judge understood that in looking at this issue, he had to consider whether the claims in the statement of claim were related as that term was defined in the policy. He found that there were, such that there was only therefore one claim. The Court of Appeal disagreed, however. It noted that the claims were related in a general nature. However, when looking at this issue, one has to go beyond mere generalities and consider the particular errors, omissions, and negligent acts underlying them. In this context, the Court of Appeal found that there were two separate and distinct claims, sufficiently different in nature so as to give a rise to two claims for the purpose of the policy, thereby increasing the aggregate limit to $2 million. Hincks and Gallardo. When Mr. Hincks and Mr. Gallardo entered into a civil partnership under the UK Civil Partnership Act, they no doubt failed to consider what would happen if they separated. Unfortunately, that is exactly what they did in Ontario, and what happened is that Mr. Hincks then sought relief under the Divorce Act and Family Law Act. At issue in this appeal was whether or not they would be considered spouses and whether or not they were married. The Court of Appeal held that a civil partnership under the UK Act was the functional equivalent of marriage, and that the parties had chosen an economic relationship with the same rights and responsibilities of marriage, including at breakdown. The Court found that the fact that the UK Act only allowed for civil partnerships, as well as the fact that the parties may have had different subjective intentions, was not relevant to their consideration. The effect of the Act was to bestow on the parties certain rights and responsibilities, and those flowed through such that the Divorce Act and Family Law Act provisions would apply.